May it please the court. My name is John Metter. I'll be representing the state. This case originates out of Montgomery County and it involves illegal voting and statutory mistake of law instruction. I'd like to start with the indictment and the language of the charge because one of the key elements in the statutory mistake of law defense is the phrase conduct charged. So I think the best place to start is to look at the indictment and the charge and then apply that to this particular case. James Jenkins was charged with voting in the May 2010 road utility district election when he knew he did not reside in the precinct in which he voted. The jury charge tracked the indictment and turned on whether he knew he was not eligible to vote because he knew he did not reside in the precinct in which he voted. So before starting to discuss the mistake of law instruction itself, I think the first place to start is to ask if a mistake-related defense applied here at all. Once the state proved beyond a reasonable doubt that he knew he wasn't a resident of the RUD when he voted, that finding negated mistake. I think the state had to prove or disprove mistake as a necessary element of a knowing violation.
Well, so do you disagree then with Professors Dix and Schmolsky, who most criminal law folks think are upper echelon in terms of their brilliance? They said they've observed that although the caption of the statutory defense is mistake of law, a more accurate statement would indicate that a limited exception is recognized for reasonable reliance upon an official written statement of the law. The defense may be valid where the defendant shows that he or she acted in the belief that the charged conduct did not violate the law and that the belief arose from a reasonable reliance on an official statement of the law.
I agree with that.
So that seems to completely contradict the argument you just made.
Well, I think that the key to that is charged conduct. Conduct is defined in the code as an act and mental state, and then that's why I wanted to start with the charge. So taking the language out of the charge, he knew he did not reside in the precinct in which he voted. What's the charged conduct then is that he reasonably believed.
Well, you're missing the first part of the phrase. It's when the defendant knew he was not eligible to vote because, so the issue is whether he knew he was not eligible to vote, and that's where the mistake of law comes in, that he consulted with the lawyer and various other folks, and the Attorney General and the AG of Montgomery County, and so he thought he was eligible to vote based on the legal advice of your office.
And that's why I think initially the place to start is to determine whether mistake-related defense applies at all in this case, because he said, I read all of these authoritative opinions and I did everything everybody told me to do, and we still had to disprove that in finding, the jury had to disprove that in finding that he knew he was not a resident when he voted. In other words, that's part and parcel of the language of the statute. Regardless of how much he had, let's say he, just had to know a few facts about where he lived, or if he had to know everything there was to know about the election law. Once that came out in the state's case in chief, we necessarily had to negate that to get a jury finding beyond a reasonable doubt that he knew he wasn't a resident when he voted. In other words, that all came, it's a failure, this is, I believe is simply a failure of proof defense and not one of these statutory affirmative defenses, which are different. I see mistake of law as more like entrapment or duress or necessity or insanity because they're really in the nature of an excuse and not trying to negate a mental element of the. So I can also give you another reason why the negation of the mental element can't be in this statute is because it's an affirmative defense. That means the defendant would have to disprove an element of the offense. There would be overlap between what the state had to prove and what the defendant had to prove, and he would have to bear the burden of persuasion. That violates due process. It cannot be that.
Who makes the mistake? The person voting or the person who gave the erroneous opinion as to residency?
I think it's the person making the erroneous those administrative decisions. This is how I understand it to work. in the nature of confession and avoidance. I did it, but they told me I could do it. And I can give you two examples of cases in the Supreme Court that sort of,
So the mistake, and I apologize for interrupting, the mistake was back when they made the wrongful determination that that was a valid way to vote? I mean, valid, that you had enough residency to vote?
no, what I'm saying is that what those administrative law decisions had to say was that you could vote in this election without having established residency. And I can give you two examples of that real quick.
That's where the mistake is.
Right, it's their mistake. And he relied on it to his detriment.
So the mistake of law, instruction goes to his mistake, though. He's mistaken in relying on it then.
Right, in other words, that would be a failure of proof defense, in my opinion.
Well, I'm
So-
trying to figure out what has to be proved one way or the other. And does the defendant, is the defendant not all he has to prove, for the instruction, he just has to prove that he relied on what he thought was a valid opinion.
Yeah. No, Judge Stevens, in this case, having read you can see in the language you can hear him thinking when he rules on this particular instruction. He reads it, he says it's an affirmative defense. The only contested issue in this case has been your eligibility to vote. You haven't admitted to it, therefore I'm going to deny your request. However, as I understand your defense, you're saying that your mental state was intertwined with the case that the state had to prove, and that's part of the reasonable doubt instruction.
There's no doubt he relied on it. And so the state's, I mean, he basically testified. I mean, you had all that in the jar. So
Right.
it's just having to decide whether it was
A mistake is, first of all, saying that I read everything there was to read on election.
Does he make a mistake?
He's
in
not even
relying
a-
on a mistaken opinion then?
No, he's not even
Is it-
saying
is
he
it a
made a
double
mistake.
mistake?
He's not even saying he made a mistake.
Well, I'm not asking you for that. I'm asking
Okay.
you, is that part of the equation, though?
Oh, the admission of a mistake, it's either got to be,
I mean, does he have to show that he made a mistake in relying on a mistaken opinion, and therefore, you all have to prove the opinion is mistaken, and then you've already got it, that he relied on it?
I think, if I followed you right, if you're asking whether the state has to negate mistake, I'd say yes, because of the way the statute's written. Because we have to show actual knowledge of residency.
Do you have to negate that the opinion he relied on is mistaken?
Oh, we have to negate his mental state. So the fact that he read it and then formed this opinion that he was in fact a resident.
Do you have to negate that what he relied on was wrong?
Oh, it doesn't, I mean, the nice thing about the reasonable doubt instruction, whether those opinions say what they said, he said they said, or whether they don't, it's all part and parcel of the reasonable doubt instruction. It didn't matter whether his reliance was reasonable or unreasonable, whether those opinions were right or wrong. It simply mattered what he was thinking when he voted. Once the state proved that he knew he wasn't a resident, we necessarily disproved everything that he was relying on to his detriment, and believing he was a resident. So that's, I think, one of the most difficult things about this case is this idea that a mistake would even apply here, because of the standard the state has to prove is that he knew he was a resident.
Did the state actively oppose the instruction?
Yes, we did.
Why would the state actively oppose it if it was just sort of, you already disproved it anyway? I mean, what would be the big deal about including an instruction like that?
I think the confusion on the mistake of law instruction in the 803 instruction is to believe that the negation of an element of the offense is embedded in that statute. It can't be. It can't be.
But the legislature didn't write mistake of law the way you just said it. The legislature that wrote the law says it is an affirmative defense that the actor in reasonable reliance upon an official statement of the law. You are rewriting what the legislature said. The legislature didn't say, well, if it's an element of the crime, because the crime requires knowing, then you don't have to instruct on mistake of law. The legislature said the exact opposite. It is that you instruct when the evidence raises the issue. So why shouldn't we just follow the plain language of what the legislature said?
Well, I think the plain language is where my case is the best. So let's look at conduct charged. What was he charged with? Voting knowing he wasn't a resident. He had to believe that voting knowing he wasn't a resident did not constitute a crime. You have to substitute the word out. This is what the dissent said. So that you have to take the language out of the charge, stick it in the statute, and then see where you are. So this is how it works. A couple of cases, this mistake of law instruction comes out of the model penal code. And two of the big cases that sort of went into the model penal code were Cox v. Louisiana and Cox and Raleigh v. Ohio. The first case involved some protesters outside a courthouse. It was in the 60s, they were protesting. Police told them to go closer to the courthouse and protest. Go over there. They were ticketed for protesting too close to a courthouse. Their defense was that they told us to do it. So the conduct charge was, it was against the law to protest this close to a courthouse. He told us to do it. That's mistake of law. The conduct charge was breaking the law. You told us we could break the law. The next case was the Raleigh v. Ohio. Some folks were testifying in front of a Ohio legislative committee. The chairman said, you know what, you can invoke your Fifth Amendment privilege against them. That was wrong. They'd been given blanket immunity, and they were all charged with failing to cooperate with that legislative committee.
Well, let me see.
The conduct charged in that case was invoking the Fifth Amendment privilege when you had no right to. You can now blame those, back to your first issue, we're blaming these people for giving you wrong advice, saying you can vote in this election without having established residency. And I gave you an election law case that sort of went out of New York that was along those lines. This guy, you look like you want to ask me a question.
But I don't want to interrupt you.
Okay, so a man lives at home, he has a residency there, he gets married, he moves outside that particular district or area. His wife changes her residency, he doesn't. He goes back and votes in place A. He's charged with illegal voting, and the court said, if you'd brought in some cases, he asked for, mistake of law instruction, if you'd brought us in some cases that said that you can vote in an election in a place where you used to have residency, then the mistake of law instruction applies.
Well, okay, you all only had to prove that he voted knowing he was not a resident in that voting
Right.
district. But does that tell us that he knew that was against the law?
Yeah, he needs to know the facts. Residency is defined as domicile, and domicile is defined as home.
Understand that.
Right. So, no,
But
he doesn't, he just needs to know the facts of his residency, where you live.
Y'all didn't have to prove that he knew that was against the law?
No,
Why?
because residency is defined as habitation, which domicile, which is defined as home. where
But
you-
who knows that residency is required to vote in a certain election?
Who doesn't?
I mean,
I think everybody would know that.
so you,
So, you're saying, to know if you have the right to
delay
vote, I
case,
think,
in the delay case,
yes.
the underlying crime that delay had to have for there had to be a predicate crime,
Right.
which they said was the corporate giving.
He had to know he was giving.
No, not them.
Okay.
They had to prove that the corporation knew that they were giving money that was going to individuals, and they had a double standard that they had to prove not only that they knew that they were giving the money, that they knew that it was against the law.
Right.
And so that's what
This
I'm
statute
saying
says you
here
have
is
to know-
why would that standard not apply here?
Because it says you have to know where your residency is, and residency has a
Where's it
particular.
say? I mean, he knows that before he votes.
Well, I think, yeah, I mean, I think if you were asked somebody, where's your residency? Well, I have a home, or I live over there, or I have a,
I thought he admitted he wasn't a resident in his testimony.
No, he believed he was a resident of the RUD.
Okay, but just proving that he was not a resident doesn't prove that he knew that was against the law.
Yeah, my time.
Please continue.
I guess this goes back to the Thompson case that I quoted, I think 1888, where this came up, where a man voted, and he was a felon. And by law, you couldn't vote. The court said the fact that he knew he was a felon, the state would be nearly impossible for the state to prove someone, knew they were breaking the law. All the law requires the state to prove are the sort of the factual situations, the facts on the ground. He knew he was a felon. Being a felon is enough to negate, to sort of strip you of your right to vote.
That was the actual point that I made in delay. How were you going to prove that a corporation didn't know that it was against the law to actually give a contribution but if that's the law now, I mean, and why should we not apply that to other situations? Even more so to an individual who's not going to be sitting here being, is aware of the laws on voting as a corporation should know on giving corporate contributions.
And I think the issue here is the instruction and not, I understand.
My question, and here's my quarrel with what your whole argument, is that you're reaching the ultimate merits on whether he would have ultimately prevailed on a mistake of law defense. And that's not the question in front of us. The question in front of us is, did the trial court err by failing to instruct the jury as to the affirmative defense of mistake of law? And when answering that question, you view the evidence in a light most favorable to the defendant, not as what you've purported today, which is in the light most favorable to the state. What he said was a bunch of garbage. And maybe if I was on the jury, I might have said, hey, what he said is a bunch of garbage. But that's not the issue. The issue is viewing the evidence in a light most favorable to the defendant. Was there any evidence to support the giving of this instruction? And that's what I don't think you've addressed this morning.
Well, the sufficiency of meeting this instruction, according to Judge Stevens, was not the issue. It didn't apply because it was an affirmative defense, and he didn't admit to the conduct charged. It's the wording of the statute itself that doesn't apply here, not whether he had. In order to have this apply, he needed to. It was confession and avoidance, and it's confession and avoidance based on the way it reads. And it's also an affirmative. If the Court of Appeals decision stands as it is right now, there's nothing to stop us from this point forward, from the state, from asking from this mistake of law instruction, because the mistake of law instruction, as interpreted by the Court of Appeals, now puts the burden of proof on the defendant on an element of the offense. That violates due process, and there's hundreds of cases.
No, that's only if you ignore what Professor Dick said. I think we're probably just disagreeing as to the meaning of
I agree that this is a reliance-based defense. It's an estoppel-based defense. I think that's what Professor Dix is saying. It's you had to rely on misinformation. You had to rely. It's sort of in the nature of an entrapment. I did it, but they tricked me into it, is what an entrapment is. This is, I did it, but they told me I could do it. It being the illegal conduct. The illegal conduct in this case is voting.
He didn't prove that.
Excuse me?
He has to say he relied on it.
He had to rely on, he had to bring in a decision in which it said, you can vote without having established residence.
He didn't have to prove they tricked him or anything like that.
Well, I'm comparing it to entrapment, because the language of this statute of
That's
this.
not a valid comparison.
Well, actually, in Cornett, this court, in addressing whether the medical care defense was in the confession and avoidance, said you do two things. Does the defense, the 803 in this case, defense, on its face negate the culpable mental state necessary for the commission of the offense, and then you compare it to other sorts of similar statutes. This particular defense reads, I'd like to go, if I can continue. This is the way insanity reads. At the time of the conduct charged, start there. Duress, the actor engaged in the prescribed conduct. Necessity, the actor reasonably believed the conduct was immediately necessary. Entrapment, the actor engaged in the conduct charged. Each one of those is confession and avoidance. Yep. The next one. It is an affirmative defense to the prosecution that the actor reasonably believed the conduct charged did not constitute an offense. What was he charged with? Voting when he knew he wasn't a resident. So he reasonably believed that voting when he knew he wasn't a resident did not constitute a crime. That's because they told me it did not constitute a crime. The crime in this case was voting without establishing residency.
Well, why don't we let the
Okay.
defense tell us why you're wrong, and then we'll,
I think you did pretty good.
then we'll bring you back up here for another grilling. So,
Good morning, may it please the court. I'm George McCall Seacrest Jr. from Houston. Pleasure to be back. The state is wrong.
you used to
Court
brief
of
at this court,
Appeals.
didn't you?
Hello?
You used to be a clerk at this court, didn't you?
Many years ago, Your Honor. Many years ago.
Did we have the penal code and stuff then?
We did. We did. You didn't have codified rules of evidence then.
Okay.
But
Have you
now we
learned- Have you
do.
learned them since then?
I've tried to.
Okay.
The state is wrong with all respect, and the Court of Appeals got it right. Let's start from the beginning. We have to strictly construe the defense. We strictly construe offenses. We have no common law offenses or defenses. They all emanate from the legislature, so we have to strictly construe it. There's nothing ambiguous about the wording of this specific affirmative defense. The word mistake appears one time, that's in the caption or the description of the affirmative defense, but the jury never gets plied with the word mistake.
Did the defendant ever concede that he did not establish residence?
The defendant always took the position that he did not violate the law, that he did not knowingly vote believing that he was not a resident. He believed he was a resident where he voted.
So his contention was that was his residence.
Yes.
Here's the problem I see,
Yes, Your Honor.
is that the state is saying they don't have to prove that he knew that he wasn't, that voting outside of his residency in this district is against the law. And I'm thinking, that's where, in relation to your defense, that's where your defense really would go to that. And I'm thinking, in relation to what some of the case laws come out of the court, out of our court now, is that that was part of the burden of the state to have to prove he knew it was against the law to vote that,
Well,
that way.
you know,
Because he admits he admits he thought that being at that hotel was enough to be for residency.
That's what he thought. And the question is, Your Honor, is whether or not the evidence established whether that was reasonable or not, which, as Judge Alcala points out, as you all have explained ad nauseum, especially in Granger v. State, whether or not the defendant acted reasonably, whether he reasonably believed anything, that is a question not for the trial court. That's the question for the jury to resolve. But the bottom line is, this is not a confession and avoidance statute. In fact, by its very nature, it negates the culpable mental state. He says, I didn't violate the law. I didn't knowingly do anything against the law. In fact, what I did was I followed the law based upon reasonable reliance on the very authorities that the district attorney's office suggested that he cover.
Mistake of fact and mistake of law, to me, are really close in this case.
Well, they're close, but with all respect, they're different in a number of ways.
Well, I know, and I agree with you there.
Yeah.
And particularly in what, because a mistake of fact has to have confession and avoidance, doesn't it?
Yes, but yes, sir, it does. But,
And-
What was the defendant's mistake here?
well, I don't know, quite frankly, if there is a mistake here.
But you're sick, okay.
Okay?
Follow up on that.
Let me tell you why, is that one could say ultimately that he was mistaken in his interpretation of the concept of residency, that he was mistaken based upon the statute, he was mistaken based upon the law. One could say that. But it wasn't necessary for Mr. Jenkins at any time to concede that he was mistaken. The issue is, in order to be entitled to an affirmative submission of the mistake of law defense, the issue is there a modicum of evidence which establishes that he reasonably believed that his conduct didn't violate the law based upon his reasonable reliance on authoritative official statements of law. The latter is never disputed. What he relied upon is Secretary of State opinion, and of course, as the court knows, that's the chief election officer. He relied upon the Attorney General opinion. He relied upon Mills v. Bartlett, both the opinion in the Supreme Court and the Court of Appeals. He relied upon advice of counsel. He relied upon the fact that the official registrar of Montgomery County had included him on a
Can I
list of
interrupt you?
eligible voters.
Because here's where you can help me.
Yes, sir.
Okay? You can help me if you can explain, because it seems like there's different issues at play here. One of them seems to be legally, what does it take to be a resident? And the other one is information that he was permitted, that he might be allowed to vote. And so I'm trying to figure out, if somebody comes and tells me, let's say the Attorney General tells me, Kevin, you're allowed to vote in Travis County, right? And maybe I'm not a resident here, but they've told, the Attorney General told me I could vote here. Am I mistaken about whether I'm a resident because of that, or am I mistaken about whether I'm allowed to vote? And I'm trying to figure out what is the mistake?
You know,
And is it your contention we don't have to worry about that?
I don't think you have to worry about it, and quite frankly, in your circumstance, maybe you're mistaken on both fronts. I don't know. I think the issue here and the problem here is we get sucked into this notion, and basically, with all respect, it's an excuse to cover for the fact that the district attorney's office opposed a mistake of law. The trial court went with it. I understand the next case that they tried, in fact, they didn't oppose mistake of law at that time, but in our case, they opposed it. Now they're trying to come up with some justification as to why this is not error. The bottom line is the elements of the defense were absolutely raised and satisfied. The evidence is undisputed that Mr. Jenkins testified that in his heart, mind, and soul, he reasonably believed his conduct did not violate the law. And why is that? Because the district attorney's office directed him to read certain things, which he read, and subsequently he dug deeper. Here's a conscientious citizen, no criminal history, very conservative, law-abiding business owner, very interested in politics. He did his research and he made the decision, and maybe in retrospect it was an error, but he made a decision that he felt like he could change his residence in order to vote to that location where he voted. Now, he gets indicted for that. He goes to trial, and he specifically requests mistake of law instruction, and he doesn't get it. Trial court says, yes, Your Honor.
Well, let me interrupt you right there.
No, go ahead.
So if he gets that instruction, what's he have to show and prove?
If you get
Does he have to
the-
prove,
Yeah.
and let me just postulate, does he have to prove that what he was told was true or was correct law?
No, I don't think he does under the construct of 8.03. I think we had a reference to model penal code.
Mistake of law, I apologize.
No,
Is a
go ahead,
mistake of
Judge.
law what was given to him as what was the legality of the situation, or the mistake of law is that you could rely on their particular statements?
I think that had he got the instruction, then what he would have done is he would have had a a platform with the imprimatur of the district court, affirmatively telling the jury that if you believe that Mr. Jenkins reasonably believed that he did not commit a crime because he reasonably relied upon these
So
authorities.
his mistake of law is that he thought he could rely on these.
Yes.
Irrespective of the validity.
Absolutely.
Okay, so,
Yeah,
yeah.
absolutely. And this is really where it gets
Okay,
down
that's
to, is that the state on appeal and the district court at trial and the dissenting opinion in the Court of Appeal says, no big deal. His able lawyers can argue the point. Argument is no substitution for an instruction from the court, says this court, says Taylor versus Kentucky from the Supreme Court of the United States. And this court is held in the Abnor case, as you all obviously are very familiar with, that by giving an erroneous or incomplete jury instruction, it deprives the defendant of the right to a fair trial because it gives the jury no guidance with respect to its fact-finding. It's a double hickey here because on top of that, the defense counsel is left to argue that Mr. Jenkins' reliance on these authorities would be good enough for them to acquit. And there's not a word in the jury instruction otherwise addresses reasonable reliance at all. And here's why I think it's important.
Was that established simply by the defendant's testimony or by the lawyers or resources that he relied on?
What
Mistake of law. Was that established in front of the jury simply by the defendant's testimony that I got this information, or was it supported by additional testimony?
I think both.
And was it ever controverted, or did the state agree, no, we agree with you, you got the information, you just don't get it?
That's right. The state acknowledged that the Defense Exhibit 1 and 2, which is Secretary of State opinion, and the opinion from the Attorney General would come in, but they were strenuously opposed to a mistake of law instruction. And here's another problem with that.
And before you go any further, was that information obtained by retaining a lawyer to advise them on that, or did they just get it on their own?
Now, let me tell you, it's interesting, is just quickly, is First Assistant Phil Grant from the Montgomery District Attorney's Office basically was pigeonholed by the Rudd powers that be and wrote letters to these folks who had planned to vote in that election. He didn't tell them they couldn't vote. He didn't explain to them what the definition of residency was, but he said what you might want to do is consult an attorney, and you might want to read these authorities. Mr. Jenkins not only read those authorities, which cited primarily Mills v. Bartlett, he went and read those cases, and he read the cases cited in that.
Okay, so a voter has the right to rely on that then, doesn't he?
Absolutely.
So there's really no mistake of law then, is there?
There is a mistake of, well, here's the bottom line. I'm not convinced there's a mistake of law.
Okay.
Based upon the caption. I'm convinced, though, based upon a fair reading of 8.03, that if I'm defending someone and we're contesting the culpable mental state, and that culpable mental state has something to do with law or knowledge of law or principles, and
I'm going to interrupt you.
Sure.
I think that what the state is doing is coming back and saying, it's not a mistake of law for you to rely on that, because those authorities are normally viable authorities you can go to get an opinion as to whether what you're going to do is correct or not. What the state is saying, you don't get it because they were wrong as far as what they were saying. And therefore, that comes, but that's not the crux of a mistake of law. The crux is, did you have the right to rely on their statements?
You know, again, absolutely true, Judge Meyer. That's not the crux. And as Judge Alcala said early on,
She pretty much explained it correctly as
I was
to.
going to say, it might be a misnomer. Maybe instead of it being captioned mistake of law, it should be called following the law, because the defendant thought
Yes,
that,
exactly.
that he was following the
Exactly.
law. So it's really a miscaption,
But they're-
and it causes a lot of
But,
confusion.
but the state's coming back and saying, you don't get it because they were wrong on what and we don't know whether they were wrong or not.
All I know is this, is Mr. Jenkins gets indicted, he stands before a jury, he pleads not guilty because in his heart of hearts, he doesn't believe he knowingly violated the law. Why does he believe that? Because he consulted counsel, he read the very authorities that they asked him to read. Those authorities in themselves say that this is a sticky situation, it's vague, it's indefinite. Reasonable men and women can differ as to what this concept means. So at his peril,
Did his attorney testify that he advised him that it was appropriate to do what he did?
no, let me tell you, I'm glad you mentioned that, Judge Richardson. His attorney testified that he scrupulously went over all of those authorities with Mr. Jenkins and explained to him his, Mr. Yalek, the attorney's view as to what the authorities said, but the trial court would not allow Mr. Yalek to express his opinion as to whether or not it was in fact lawful or not. Now, the evidence outside the presence of the jury establishes that he in fact informed his client that he thought that his conduct was fully lawful, was absolutely within the boundaries of the law. And Mr. Jenkins, when he testified that not only did he read those opinions and the case law, he consulted counsel, and after having done all that, he felt very comfortable in his decision. The problem with the absence of the mistake of law and why, the state's position, in all respect, it's sophistry. Their position is, well, we had to prove each element of the offense beyond a reasonable doubt, so that's basically subsumed mistake of law. That's not the case
We'll be able
at
to
all.
read those resources, but was there some dispute in trial? Did the state say, no, you just misunderstood what you read? It didn't give you the authority to do that?
I don't think the actually word mistake, misunderstood was ever used. The state poo-pooed those authorities and basically says anybody knows that you vote where you live. That was their mantra. Nobody, they specifically argue, you don't need to read these things.
But to what degree, and this is, to what degree, if at all, should we defer to a trial judge's determination about the reasonableness of the defendant's reliance on something that he claimed was a mistake?
Rarely, if ever.
We should not defer to the trial judge's?
No, I'd say you should never, maybe you never use the N-word, but rarely defer to the trial court. This court has held that in Granger with respect to constituent elements of reasonableness, whether or not the defendant acted reasonably, whether he thought something was reasonable. That is inherently the type of calculus that should be performed by the jury, not the trial court.
But according to 8.03, is the reasonableness something that is sort of supposed to be, we're supposed to assess that from the perspective of the defendant, whether he thought he was acting reasonably, or is it whether he was acting reasonably in an objective sense in relying upon the things that he said he was relying upon?
I don't know how, does reasonableness really come into this?
Well,
That's in the statute.
It does in the sense, you're right, Judge Erie, this is what I'm trying to say. It does in the sense is that the construct of 803 is that if the defendant reasonably believed that his conduct did not constitute a crime, and he also reasonably relied upon authoritative sources,
And
then-
that's an objective reasonable, isn't it?
I believe it is.
Okay.
Yeah, I believe it is, but here's why their beyond a reasonable doubt argument, quite frankly, falls flat, in my humble opinion, is that when Defense Exhibits 1 and 2, the Secretary of State and the Attorney General's opinion, the very authorities that Mr. Jenkins relies on and bases his claim of reasonableness on, when they're offered into evidence, the trial court says to the jury, you may consider that if you choose, doesn't instruct them that they have to consider it. So it'll be there, and you may consider it if you choose. No, that's not the case at all. If, in fact, the state is able to prove each element of the offense beyond a reasonable doubt, then and only then does the affirmative defense kick in. And I don't have any interest in the royalties, but I contend that former presiding judge,
Hard on that.
that's true. Former presiding judge McCormick's and Blackwell's proposed instruction is the accurate jury charge that addresses the present iteration of 8.03. And what you have is an abstract instruction, which basically sets out 803, and then this is what the jury should have been instructed.
Well, I'm sorry to interrupt you, but your time is almost up, and I still want to ask you this one question.
Sure.
I'd like to hear
Oh, go
this.
ahead. I apologize. Judge Myers.
Well, I
wants to-
apologize to you both. I can do both. But after you do the abstract, then what the jury should have been told is, now therefore, if you find and believe from the evidence beyond a reasonable doubt that the defendant committed the offense as alleged in the indictment. So it's assuming the jury has found all elements beyond a reasonable doubt.
That he voted outside.
That's right, voted.
That he wasn't a resident of the district, of the district
That he didn't believe that he was a resident when he voted, that he therefore knew he voted illegally. But you further find by a preponderance of the evidence that the defendant reasonably believed the conduct charged did not constitute a crime, and that the defendant acted in reasonable reliance upon official statements of law, yada, 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 you will acquit. The jury gets no platform as to that.
Well, you kind of overstated what the state had to, they only had to prove that he just voted in a district that he wasn't a resident.
Based upon the wording of the indictment, they allege that he voted illegally because at the time that he voted, he knew he wasn't a resident of the precinct where he voted. That is the allegation.
Okay.
He testified, Judge Myers, I did not violate the law because I believed at the time I voted I was a resident of the precinct.
You have a sufficiency claim in this case then too, don't you?
Well, I think not. I think it's, quite frankly, it's just clear reversible
How
error.
did they prove that he knew? That he-
Well, I'm not convinced, at least under your construct and reading of delay, that they did. Anything else?
Gary had another question.
Oh, you had a question, then I have
I'll
a
waive
short.
my question.
Mine was just about harm, because the Court of Appeals split with Judge Busby saying that your client wasn't harmed, and so I wanted to give you an opportunity to address that.
Well, quickly, and actually it's covered by, in large part, what I just said. He is harmed because the entirety of his defense is this reasonable reliance, so it doesn't go to the jury. Jury argument can't substitute for the jury charge. And they're going to say, well, the jury must have believed he didn't act reasonably because they obviously found that he acted knowingly. I say that's not correct. Under a correct submission of an affirmative defense, we're assuming that they don't ever get to the affirmative defense unless they found all the elements beyond a reasonable doubt, but then they're specifically charged, notwithstanding the fact that you have found these elements beyond a reasonable doubt, I hereby further charge you that if you believe by preponderance of the evidence that he reasonably believed his conduct did not violate the law and he relied upon reasonable authoritative sources, you are to acquit. And of course, that is never given to the jury. That's why it's harmful as a matter of law under these facts. Thank you very much.
Thank you, Counsel.
Kevin, you didn't get to ask your last question.
That he waived.
I didn't want to.
I'm sorry.
May it please the court?
Was his sentence probated, or was it 3 years in TDC?
3 years.
3 years to do, Your Honor.
So I'd like to pick up on where you were, I think, heading on on the idea of,
And I thought Mr. Sechrist basically was showing by the charge that really negated what he says, and I guess you agree, is that you had to show that he knew that he was not eligible to vote there.
if his understanding of the mistake of law instruction is correct, once the jury found beyond a reasonable doubt that he knew he wasn't a resident of the RUD, the 803 instruction would have the jury go back in and reevaluate that same issue, which you can't do. It violates due process. So you're saying it can't both.
Due process against who? The state?
No, you can't, yeah, you cannot, well, it would be an instruction that is on its face violative of due process, because it's an affirmative defense. He bears the burden of
He
persuasion.
doesn't get due process.
Well, it would be on its face a violation of due process.
Are you saying
If the negation of the mental-
defendant's due process rights?
No, I'm saying that the statute, if it's interpreted in such a way that the negation of a mental element is within Section 803, and it's an affirmative defense, then he has a burden of persuasion on that element of the negation.
But wait a minute,
Yeah,
you're
but, excuse me a
totally,
minute.
I'm sorry,
I don't think you,
apologize.
I don't think you understood Judge Meyer's question. He said, whose due process rights?
I'm saying the statute would be, on its face, violate due process.
Okay.
It would, yeah, well, actually, it would violate his due process rights, because we're shifting to him this obligation to disprove an element of the offense. You can't,
Well,
that's not
what you do
legal.
on a lot of defenses.
Well, but doesn't the legislature have the
I
power to
think
craft
Judge
a
Alcala had-
statute?
Judge Erie, I think
That's
Judge
what, that
Alcala-
was actually,
Yeah, I mean,
I had two comments. Number one, that's what the legislature did. Whether you like it or you don't like it, that's what they did. And then the second thing is that you're mixing apples and oranges. On mistake of fact, it talks about formed a reasonable belief about a matter of fact if his mistaken belief negated the kind of culpability. Well, yeah, I see your argument there, that with mistake of fact, that sure does sound like you're going back and reassessing knowing, but that's not mistake of law. Mistake of law says that he acted in reasonable reliance upon an official statement of law from your office. And so you're mixing apples and oranges. You're trying to apply what we've said in mistake of fact cases to undermine mistake of law when they're two entirely different propositions.
Yeah, the holding of the Court of Appeals in this case said the Section 803 mistake of law goes to negate the culpable mental state necessary for the commission of the offense. That's what it says. I understand your position. That Court of Appeals decision says it goes to negate the culpable mental state. That was the whole argument on appeal, that the purpose of Section 803 was to negate the culpable mental state necessary for the commission of the offense. I pointed out that that was wrong.
Is it a double culpable mental state that you knew that you intentionally did what you did and that you knew it was wrong? Isn't that a double culpable mental state? Kinda like
If there's two of them, and then that makes it's doubly unconstitutional.
Well,
The whole thing
but
is
if
that,
but if it goes to knock out one I just don't see how it's a due process violation if they're sitting there saying, if you prove one of them, or you're saying y'all prove one of them, then but there was a reason that he acted the way he did, it's an excuse.
in this case in Lowry,
It would be like self-defense. You proved that he intentionally shot George Sechrist, but he's come back and say, but I thought the reason I was doing that because
it's a
Mr. Sechrist was coming after me.
justification. It's a justification that doesn't ask the jury to reassess any element of that offense. It's a completely separate issue.
But there's different burdens assigned to it, right? I mean, the state has the beyond a reasonable doubt burden.
right.
The defense would only have a preponderance.
If it's an affirmative defense, that's correct. Maybe I could sum up real quickly. I don't think there could be any harm in this case, because if we're into this instruction, the jury necessarily discredited his evidence in finding that he was guilty beyond a reasonable doubt. So when they found that he knew he wasn't a resident when he voted, they necessarily looked at all the evidence that he presented to them and came to a contrary conclusion.
Quick question,
Ma'am.
did he raise sufficiency of the evidence in the Court of Appeals?
No,
Thank you, counsel.
thank you.
Court will stand in recess for 15 minutes.